My name is Sandra Muñoz. I am a United States citizen. In 2010, I married Luis Asensio Cordero, a citizen of El Salvador.
Because Mr. Asensio Cordero originally entered the United States without inspection, the government required him to return to El Salvador for consular processing to obtain his immigrant visa. A consular officer denied his visa application under 8 U.S.C. Section 1182A3A2, which prohibits the admission of a non-citizen whom the officer knows or has reasonable ground to believe seeks to enter the United States to engage solely, principally, or incidentally in certain specified offenses or any other unlawful activity. No other details were given, but Mr. Asensio Cordero and Ms. Muñoz guessed that he was denied based on a finding that he was a member of the criminal gang MS-13 due to his tattoos. They appealed to us at the State Department, and we agreed with the consulate's determination that Mr. Asensio Cordero should not be admitted into the United States.
My husband cannot challenge the visa denial because he is a non-citizen with no constitutional right to enter the United States. However, I am suing the State Department because the right to live with my spouse is implicit in the liberty protected by the Fifth Amendment. Since the denial of my husband's visa deprives me of this liberty interest, I am entitled to due process, which was violated by the consular officer's failure to give a sufficient reason for why my husband is inadmissible to the U.S. under the unlawful activity bar.
I'll be the judge of that. The question we will rule on today is whether the denial of a visa to the non-citizen spouse of a U.S. citizen infringes on a constitutionally protected interest of the citizen. And our answer is
no, a non-citizen spouse's visa denial does not infringe on a constitutionally protected interest of a U.S. citizen.
I concur.
We dissent.
You're siding with the State Department. How did you make that decision?
The Fifth Amendment requires the government to provide due process of law before depriving someone of life, liberty, or property. When considering whether to extend due process clause protection to an unenumerated right or liberty, such as the liberty to live with one's non-citizen spouse in the United States, we undertake a two-step inquiry outlined in our decision in Washington v. Glucksberg. First, we must carefully describe the asserted fundamental liberty interest. Second, we must ensure that the liberty interest is, objectively, deeply rooted in this nation's history and tradition. The right of United States citizens to have their non-citizen spouses admitted to the country is not deeply rooted in our nation's history and tradition. On the contrary, throughout the United States history, the admission of non-citizens has been characterized as of favor, not of right. Immigrant spouses of citizens have never been exempted from inadmissibility restrictions, such as the unlawful activity bar that Asensio Cordero failed to clear.
I concur. However, the constitutional question no longer has any practical relevance. Muñoz sued for further explanation of the decision to deny her husband's visa. Over the course of this litigation, that further explanation was provided. Therefore, I would reverse the decision of the court below without reaching the constitutional argument.
I dissent. Excluding a citizen's spouse from the United States burdens her right to marriage, and that burden requires the government to provide at least a factual basis for its decision to exclude. In Kleindienst v. Mandel, this court held that when a visa denial implicates a citizen's constitutional rights, the government must give a facially legitimate and bona fide reason for the denial. Contrary to that decision, the majority today holds that Muñoz's right to marry, live with, and raise children alongside her husband entitles her to nothing when the government excludes him from the country. Asensio Cordero was excluded from living in the United States with his wife solely based on one consular officer's belief that he planned to engage in some unspecified unlawful conduct. Despite Asensio Cordero having no criminal history in the United States or El Salvador, and the State Department stood by the decision even after Asensio Cordero submitted a statement from a court-approved gang expert saying none of his tattoos were gang-related. In denying Muñoz a factual basis for her husband's banishment from the United States, the majority has departed from long-standing precedent and has gravely undervalued the right to marriage in the immigration context.
I disagree. Unlike this case, Mandel was not a procedural due process case. In Mandel, A group of professors argued that the denial of a visa to Belgian Marxist Ernest Mandel directly deprived them of their First Amendment right to hear Mandel speak at academic conferences. The professors did not argue, analogous to Muñoz, that their First Amendment rights entitled them to procedural protections in Mandel's visa application process. Contrary to what the dissent argues, Mandel does not hold that a citizen's independent constitutional right gives her a procedural due process right to a facially legitimate and bona fide reason for why someone else's visa was denied. Muñoz is not constitutionally entitled to such a reason here.
You rule, Supreme Court.
You suck, Supreme Court.